Hello, I'm back. Hello, Summer Marie. Second live of the day, and we are back with Sandra Birchmore. We are going to read, I haven't read these yet, obviously, a March 26, 2026 document, and then we're going to read the recent one on 4/6. So I want to just make sure I stay caught up with Sandra Birchmore. Sandra Birchmore is we've been covering her here. We just actually did a live on a timeline of the case. If you're interested, go listen. She was unalived by allegedly a police officer with Stoughton Police Department, and the new document actually has information regarding evidence found on her person. So we're gonna get right into it. I've been dying to read this document. It's pretty lengthy, so we'll be here for a little bit. But if you missed the last live, we did cover a plethora of cases. Michaela Settles, Lynette Hooker, and Anna Kepner. So definitely make sure you go back and replay that live. Hello. Thank you, hoodies. I already thanked you, but thank you again for becoming a member. Debbie, Evie, I know Cree's about to be in here. Hello, Summer Marie, Angel Eyes, Debbie, Joker. Hello, Badass Dodgers. Hope you're having an amazing Tuesday. Thank you. You too. I hope you guys are having an amazing Tuesday. I will be live pretty much all day. This is the second live of the day. I will be doing 𝗠𝗲𝗹𝗆𝗆𝗆𝗆 after this. So let's get started with the documents. Sorry. Switch my screen. Oh, I'm sorry, Summer Marie. Sorry to hear that about your stepfather. Sending you lots of love. You're good. Don't worry about it. But thank you for being here. Okay, let's see. Filed March 26, 2026, opposition to government's motion for pre-detention. Okay. Remember, this is the case where both of the twin brothers had been grooming and having an inappropriate relationship with Sandra Birchmore. Matthew Farwell, okay, let's see. By through and undersigned counsel, requests that this honorable court conduct a detention hearing and release him pursuant to the Bail Reform Act. He submits that the government cannot meet its burden to demonstrate by clear and convincing evidence that his release would pose a danger to the community, or by a preponderance of the evidence that he presents a serious risk of flight or obstruction, that he must be released. He further submits that the factors set forth support his release on pretrial conditions. You know what? I actually wanted to look something up really quick. Yeah. Okay. Let's continue. Hi, Chris. As discussed below, Mr. Farwell's personal history evinces extraordinary service to both his country and his community. He has extensive family and community ties with the Commonwealth of Massachusetts, and he has no prior criminal record, convictions, or arrest. Perhaps more tellingly, however, in the years after Miss Birchmore's death, and notwithstanding the lengthy MSP investigation and excessive press coverage, Mr. Farwell conducted himself like the innocent man this court presumes him to be. He lived in the same home with his family, including his 3 young children. He built his business from the ground up. He maintained the same contact information and associations. He participated in the attendant civil suit and mass post proceedings, and he did not intimidate or influence any witness nor destroy any piece of purported evidence. Should he be released on the conditions proposed below or any other condition the court deems just, he will appear for trial and comport himself in the same peaceful and respectful manner as he has over the past 5 years. Except you didn't. You were having sex with a 13-year-old girl. Rolling my eyes. Although the BRA presumes pretrial release on personal recognizance in this case, there is a panoply of release conditions available to reasonably assure that Mr. Farwell's appearance and the safety of the community. These include release to his mother as third-party custodian, live with third-party custodian, maintain residence, and do not move without prior permission. Ah, that's funny. live with your mom because your wife wants nothing to freaking do with you. Do we blame her? No. Confinement to residence with exceptions for legal, medical, mental health, employment, and family obligations are approved by the probation department. Submitting to location monitoring, restrict any approved travel to the District of Mass, surrender any active passports to the U.S. probation, and do not seek new travel documents during the tendency of the case. No contact, direct or indirect, with any witnesses in the case. Submit to any required testing for you-know-what and alcohol. Refrain from possession of any firearms, destructive device, or any other dangerous weapon. Submit to an unsecured bond in the amount of $50,000 and report to U.S. probation and pretrial services as directed. Mr. Farwell offers these proposed conditions for the court's consideration, but argues that he is entitled to the least restrictive set of conditions that the court deems appropriate. Whatever. Background: Sandra Birchmore's death by well, I'm annoyed. It says by self-deletion here, but that's not true. But anyways, I guess until trial. Sandra Birchmore's death by self-deletion was a tragedy, and the federal government's allegation that Mr. Farwell instead unalived her are undoubtedly serious. Undersigned counsel expects, however, that much of what the government declarative states as fact in its motion and accompanying affidavit are issues that will heavily be contested and litigated at trial. Whether Ms. Birchmore's death was a self-deletion, as the Mass Office of the Chief Medical Examiner pronounced, or a homicide, as the federal prosecution alleges, is a critical issue in this case. One upon which the government ultimately bears the burden of proof beyond a reasonable doubt. This is especially true where Sandra Birchmore had a substantial and documented history of self-deletion ideation. On February 1st, 2021, the date the government alleges that Sandra was unalived by defendant, she Googled the following: what color is the self-deletion ribbon? Dr. Maria Capo-Martinez, the forensic pathologist employed by the Massachusetts Office of the Chief Medical Examiner, conducted the autopsy of Sandra. The OCME ruled her cause of death a self-deletion. The government sought a second expert opinion from an additional board-certified forensic pathologist and ME, this one employed by the U.S. government. That forensic pathologist and medical examiner concurred with the OCME's finding that Ms. Birchmore did commit self-deletion. No. The government, rejecting these expert conclusions, sought a third opinion from William Spafford Smock, a specialist in the field of emergency medicine. Dr. Smock opined that Sandra was strangled and died by homicide. Dr. Smock is not a forensic pathologist, nor is he board certified in any specialty. On October 24th, 2024, Fox 25 News reported that on August 16th, 2024, 9 days before Matthew Farwell was arrested in this case, Dr. Smock, along with individuals from the MSP and the FBI and the U.S. Attorney's Office, met with the Chief Medical Examiner, Dr. Mindy Hull, and Dr. Maria Capo-Martinez at the office of the OCME. Two sources told the news outlet that federal authorities wanted Dr. Hull to know they disagreed with the determination that Sandra died from hanging herself. Despite efforts by the government and its retained expert to meet with OCME regarding its opinion of Sandra's cause of death, the OCME has not changed its conclusion that Ms. Birchmore died by her own hand. Hi, Belita. Regardless if self-inflicted or not, he's to blame for her passing. I believe he did it either way, but he's the reason she is gone. Yes, I agree with that, hoodies. I absolutely think he was responsible, but that is just my opinion. And yes, of course, innocent until proven guilty. But I mean, come on, there's video of him leaving her apartment. I don't know. Thank you, Debbie. Hi, Evie. Good to see you, love. Although it should be this case, just this one with the Michaela one really got to me in the last live. It's upsetting. especially when, someone in power, aka the police, are involved. But this case is kind of run by similar people, if not people involved in the Karen Read case. So there's that as well. Although it should be obvious that given Mr. Farwell's right to be presumed innocent, the district court's recent caution may be repeated. The government's allegation against Mr. Farwell are just that, allegations, and have no evidentiary significance. Consistent with Mr. Farwell's position that his innocence will be borne out at a trial and that the government should try its case before a jury and not in the court of public opinion, the forum to determine his guilt or innocence is not a detention hearing. Determinations of pretrial detention or release do not modify or limit an accused's presumption of innocence. The weight of the evidence is the least important of the various factors, lest a court make a pretrial determination that the person is guilty. Even when charged with serious offenses, there is no mandate or requirement that the defendant be detained, and that the Bail Reform Act explicitly permits release, even for those accused of the most serious crimes. Indeed, the very reason that Congress directed district courts to consider factors beyond just the severity of the offense is the recognition that an individual is more than the crime of which that individual has been accused. As outlined below, Mr. Farwell's personal history and conduct while under microscopic scrutiny for more than 3.5 years prior to his federal indictment demonstrate his respect for the law and the proceedings. Mr. Farwell's established history substantially reduces, if not eliminates, any concerns regarding serious risk of flight, obstruction, or danger to justify release in this case. So he's saying he wants to be out on bond while he awaits trial. But the next document we're reading will absolutely tell us no, he should not be on bond with new evidence. So let's continue. Mr. Farwell's ties to Massachusetts and military service. Matthew Farwell is a lifelong resident of Mass, a devoted son and father, a decorated combat veteran and police officer who has served his country and community for nearly 20 years, since he first enlisted in the United States Army when he was 18 years old. His family has deep roots in the South Shore, where his mother, wife, and children still reside today. One of the 3 children raised in a family that struggled to make ends meet in Stoughton, Massachusetts. Mr. Farwell has worked his entire life, starting with 2 jobs as a teenager at Honeydew Donuts and a local tow truck yard, the United States Army, and later for both the Wellesley and Stoughton police departments. Though he traveled internationally and across the U.S. when deployed with the Army, it is here in Massachusetts where he built his life career and ultimately his own business. No one cares. In 2004, Mr. Farwell volunteered for the Army at the youngest possible age and at a time when the U.S. was intensely involved in both the Iraq and Afghanistan conflicts, just a few years before the attacks of 9/11. The principles of service were deeply instilled in him by his father and grandfather, and Mr. Farwell thought at one time that he would make a career in the military. He completed basic training at Fort Jackson, South Carolina, volunteering and qualifying for the EOD training after passing intensive suitability test. He completed advanced individual training at Redstone Arsenal in Alabama, and Eglin Air Force Base in Florida in 2005 before reporting to Fort Bliss in Texas, where he was quickly promoted to private first class. In advance of deploying to Afghanistan in 2006, Mr. Farwell's unit at Fort Bliss partnered with local law enforcement agencies on EOD-related issues in 32 counties in Texas. While in the U.S. Army, Mr. Farwell held top secret, sensitive, compartmented information, a high-level security clearance which required a rigorous background investigation. That's like great and all, but just because he was in the military and in the Army didn't stop him from being a predator. So I just want to make that note. In March 2006, Mr. Farwell was deployed to Afghanistan, first to Bagram and then to Jalalabad, where he joined the TF Paladin, a joint service task force assigned to the EOD mission. Charged primarily with the disposal of improvised IEDs, Mr. Farwell's team disarmed IEDs by disconnecting the detonation mechanisms or placing additional, I'm not going to say that word because YouTube won't like it, additional devices near the IED and performing a controlled detonation. His team also frequently examined the remains of vehicles destroyed by IEDs to prevent further attacks. As a result of his active engagement with, in circumstances in which he was imminent danger from the enemies to the U.S., the Army awarded Mr. Farwell the Combat Action Badge. Farwell's concern for the safety of his fellow soldiers and innocent civilians alike was evident in the manner in which he conducted himself while in service to the nation. He returned to Fort Bliss in the fall of 2006, and he was promoted to sergeant and selected a team leader. You know, it's funny because they give you all this background because they're like, oh, he has this history and la, 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 la. But it's like, okay, well, when he gets found guilty in court, it's like, it's not such a good look then, So it's like, oh, you did all of this for the country and you still ended up being a PDF file and getting with a 13-year-old girl? Hey, Adrian. Yeah, The following year, Mr. Farwell began to have severe migraines and neck pain and was ultimately medically separated and honorably discharged from the Army in mid-2008. I'd like to look into that. For his laudable service, however, he was awarded the Army Good Conduct Medal, the Army Commendation Medal, and the Joint Service Medal. He was later assessed as having a 90% service-connected disability rating. Upon his return to Massachusetts, Mr. Farwell moved back to Stoughton and eventually to Easton with his wife. He attended and graduated from the Police Training Academy and first joined the Wellesley Police Department. I don't know if I'm saying that right, sorry. While with the Wellesley Police, Mr. Farwell earned several commendations for his vital work in responding to emergency scenes and saving lives. In 2012, Mr. Farwell joined the Stoughton Police Department, and within just 1 year, he received a life-saving medal, a meritorious award, and a commendation award. He was promoted to detective in 2017 and continued to accrue commendations and public service awards. Again, that's great. I'm glad you got the awards. But still, why were you sleeping with a 13-year-old girl? Moving on. State investigations. Mr. Farwell's leave from Stoughton Police was swiftly initiated following the death of Miss Birchmore. Importantly, Mr. Farwell respected the processes and the lengthy investigation that followed. Throughout the attendant Stoughton Police Internal Affairs investigation, the MSP in the Norfolk County District Attorney's Office investigation, and the POST proceedings, Mr. Farwell repeatedly showed he is far from a flight risk. Again, I note the Norfolk County District Attorney's Office. Don't forget, Karen Reed. This is, we're reading they want Matthew Farwell, Evie, to be on bail while he awaits trial. He's the one that unalived Sandra. Remember, she was pregnant and she was hanging allegedly from the door. Hey, Jason. Mr. Farwell repeatedly, I already read that. He remained put, engaged counsel, and saw these matters through to their eventual dispositions. Ultimately resigning from Stoughton Police Department in 2022, Mr. Farwell subsequently entered into volunteering decertification agreement with POST. Mere days after Ms. Birchmore's death, Mr. Farwell voluntarily spoke with MSP investigators and consented to a search of his personal cell phone. Despite the government's claim that he later Googled the topic of revoking consent in Massachusetts, he never did so. Mr. Farwell also answered a civil lawsuit by the estate of Sandra Birchmore. The civil matter has been stayed pending the disposition of this federal case. So there's a civil suit against him, and that's on hold while they determine if he is found guilty or not. Interesting. Notwithstanding, have I read that here before? After review. Notwithstanding the intense scrutiny of the state investigations, which resulted in no criminal charges filed by the Commonwealth of Massachusetts against Mr. Farwell in relation to Sandra's death, Mr. Farwell sought to maintain some semblance of normalcy for his family. Though the government concedes he, quote unquote, went on with his life, in truth, he worked incredibly hard to rebuild a life in the state where he was born and raised. Well, your wife doesn't want to be with you, but I guess. Let me take a drink of my energy drink. I don't usually drink energy drinks, but I've been on a kick lately. I don't know, probably not very good. Far from the conduct of someone intending to flee the district, Mr. Farwell took out a 10-year business loan to start his own business. Well, yeah, Matthew, because no one's going to want you to work for them when they know that you're a pedophile and like little girls. Just saying. Which he named after his 2 sons and daughter. He obtained his commercial's driver's license, purchased a semi-truck and a trailer to transport cargo and freight for his business, and registered his business with the Secretary of the Commonwealth of Massachusetts. As a combat veteran, Matthew sought out medical and mental health services from the VA. He maintained and nurtured relationships with close circle of friends and family, including his mother, who lives roughly 15 minutes away. His only travel since 2021 has been to visit family or work briefly out of state, and when his U.S. passport expired in 2023, he did not renew it. Hey, psycho. Moreover, until his arrest in this case, Matthew Farwell remained a lawfully registered firearm owner and safely secured his GUNS in a safe in his marital home. Neither before nor after Sandra's death did Mr. Farwell use any firearm to threaten or harm himself or others. After his license was suspended as a result of his arrest, all of the firearms were relinquished. More importantly, however, Mr. Farwell, along with his wife, continued to raise their 3 young children in their home. Often treated like a pariah himself by former colleagues and community members, with his name and reputation smeared across social media and the press. That's funny. Again, and you guys will get sick of me repeating this, then you shouldn't have been dating a young girl. In fact, 2 months prior to his arrest, local and national news outlets herald a report by Dr. Michael Baden, a forensic pathologist hired by the family of Sandra Birchmore. Headlines in People magazine and courttv.com, of course, proclaimed that Matthew Farwell was an alleged unaliver. Matthew did not flee the jurisdiction in response to the so-called quote-unquote bombshells. He stayed put. He did not interfere with this investigation in any way, even as members of the public here in the Commonwealth and across the country called for his arrest and prosecution. Well, no shit. Where is he going to go? He has to live with his mother, for crying out loud, if they let him out, which they didn't. Mr. Farwell remained singularly focused. Well, I don't know. We'll see. I think there's a court date coming up. Mr. Farwell remained singularly focused on providing for his family and protecting them from the curious-like atmosphere generated in the wake of Sandra's unaliving and revelations surrounding his prior interactions with her. While other men who had ongoing affairs with Sandra moved out of state after her death, Mr. Farwell remained in the same home in the same town. Put simply, for more than 3.5 years after Sandra's death and until his arrest in the case, Mr. Farwell did not behave in any way that would indicate he was either a risk of flight or a risk of obstruction. He conducted himself peaceably and sought to quietly rebuild his life. Despite this, and despite surveilling him for months, heavily armed law enforcement agents arrested Mr. Farwell while he was alone with his 7-year-old son on August 28, 2024. Mr. Farwell was respectful, he was not armed, and he submitted to arrest without incident. Procedural history. In late of 2024, Mr. Farwell was charged by indictment with unaliving a witness/victim. More than a year later, in mid-October 2025, the government superseded with an indictment charging unaliving a witness victim in violation of 18 and thereby causing the death of a child in utero. Because remember, Sandra was pregnant. Yeah. Hey, Q. The state did not renew passport, did not travel, as if he did extra. I know. That they let him be around children is insane. I agree. And they're acting like, yeah, like he's doing so much. Like everyone has to do that, right? When they're involved in a big criminal case. They're dumb. Well, like Matthew, and he pleaded not guilty prior to Mr. I'm not trying to disrespect the law enforcement, but whatever. He pleaded not guilty prior to Mr. Farwell's initial appearance. In arraignment on this case on August 28, 2024, the government filed a motion for detention. In support thereof, the government appended an affidavit by Special Agent 𝗠𝗲𝗹𝗆𝗆 with the FBI. On September 7, 2024, on the advice of counsel, Mr. Farwell consented to a voluntary order of detention without prejudice. On September 9th, 2024, this honorable court entered an order of voluntary detention without prejudice to the defendant filing a motion at any time seeking a full detention hearing and the setting of conditions of release, regardless of whether there have been changed circumstances. On December 9th, 2025, the government notified this court that it did not intend to seek the death penalty in this case. Here's their argument. There's a presumption of release in this case. The BRA directs judges to order pretrial release on personal recognizance or an unsecured appearance bond unless they find that, quote unquote, such release will not reasonably assure the appearance of a person as required or will endanger the safety of any other person or the community. Even where a judge makes such a finding, 18 U.S.C. still mandates pretrial release subject to certain enumerated and least restrictive conditions. Section 𝗠𝗲𝗹𝗆𝗆, which the government invokes in moving for Mr. Farwell to be detained pretrial, specifies certain conditions under which a detention hearing shall be held. As relevant here, a detention hearing is required where Mr. Farwell has been charged with the crime of violence that carries a sentence of life imprisonment, and the government alleges his release would pose a danger, and where the government alleges that Mr. Farwell poses a serious risk of flight and obstruction. I kind of beg to differ. I think he is a danger to other young girls and, like Q said, children. But again, let's continue. A defendant may only be detained, however, if the judge determines that no condition or combination of conditions will reasonably assure the appearance of the person as required and the safety of any other person in the community. The factors the court must consider are the nature and circumstances of the offenses charged. We've heard these kinds of things in a lot of cases. The weight of the evidence against a person, the history and characteristics of the person, the nature and seriousness of the danger to any person or the community that would be posed by the person's release. Seems as though little girls are in you were in my mind today, Q, and would be around this clown, so why should he be out? I was just going to say, really seems that children are not safe anywhere. Hey, Tess, thanks for being here. Children are not safe right now. There's a lot of evil and predators around. You must keep your children close. The First Circuit directs that due detention must be given to all four factors. But in 3142, it is notably silent about the relative weight a court should give these factors when deciding whether to release or detain a defendant. And assessing Matthew Farwell's mental condition, the court should not punish him for seeking treatment from the VA. Okay, well, wait. So you decided to seek treatment when what? When you knew that you're looking at life in prison? Or was that beforehand? It does matter because it shows that your intention was not really genuine. You're just doing it to get ahead of it, if you know what I mean. As a combat veteran, I'm sorry, I'm not very nice about PDF files, really. Some might say I'm not being fair, but they're all predators should be put under the jail, if you know what I mean. As a combat veteran, these are services to which he is entitled. His willingness to engage in treatment and his compliance therewith is commendable. No, it's not. He was working for a police department, being a fake, dating a 12-year-old, 13-year-old girl. He should be applauded for this, not penalized in assessing his worthiness for bail in this matter. Indeed, the court ought to credit any criminal defendant, especially our veterans, who identify their needs, seek out appropriate assistance, and comply with their treatment obligation. Similarly, Mr. Farwell's unblemished history of lawful GUN ownership cannot form the basis for detention in this case. The Commonwealth of Massachusetts has some of the strictest GUN laws in the country. These rules are designed to balance public safety with the rights of the individual owners. Whether in his professional capacity as a soldier or a police officer or in civilian life, Matthew abided by these rules without incident. Why, again? Same with everybody else who owns firearms and hasn't committed any crimes. So annoying. His arrest in this case necessitated the seizure of his lawfully owned firearms. There are no firearms in his marital home or his mother's residence, nor anywhere in his custody and or control. Finally, the court cannot cite Mr. Farwell's present lack of employment as grounds for detention in this matter. He has been held custody and unable to work. However, he was gainfully self-employed at the time of his arrest, and U.S. Probation Pretrial Services verified that he registered his company on January 21st, 2022, and he is endorsed to operate motorcycles, combine tank hazmat, and the operation of any vehicle that would be referred to as a double or triple. Furthermore, even if Mr. Farwell is not able to obtain employment before his October 5th, 2026 trial, he will continue to receive a monthly stipend from the VA. Ooh, so we have Courtney Clenny in the fall because it's been moved. We have Sandra Birchmore in the fall, and then I'm missing, I think, like 3 others. I have to look at my calendar. If it was some disorder he suffered from and needed treatment, then why was he so careful to keep it a secret? Doing bad things is not always due to mental health issue. Exactly, Q. We recognize and we advocate for mental health, but it's not always an issue or an excuse. You're right. Yeah, Chris says, who cares? He broke a major no-no law. True. Okay. Mr. Farwell submits that the BRA requires that he be released because as he stands before the court today, he is neither a serious risk of flight nor obstruction, nor would his release pose a danger. If the court disagrees, the detention factors support a finding that there are conditions available that in whole or in part are more sufficient to mitigate any such risk. The BRA thus mandates that he be released subject to the less restrictive set of conditions, including those proposed herein and any others which the court believes necessary to reasonably assure his appearance and compliance. Finally, any doubts regarding the propriety of the release should be resolved in the defendant's favor. I don't know. Someone with that much experience in the Army and knows a lot of people in government, like, I don't know, he might be a flight risk. Like, he might be like, hey, I don't want to be known as a PDF file in prison for the rest of my life with Gen Pop, where someone might, decide, hey, I might take him out. I don't know. Mr. Farwell does not pose a serious risk of flight, or here we go. It is the government's burden to prove a preponderance of the evidence that there is a serious risk that Mr. Farwell will flee if released, and that no condition or combination of conditions would reasonably assure his appearance at court proceedings. Evidence of some risk or a risk of flight is not enough. Neither is the mere fact of a serious charge. Here, it is because of the seriousness of the allegations and the severity of the possible punishment that Mr. Farwell has every reason to return to court. Well, that's why I'm saying he has every reason to book it. He seeks first and foremost, I guess that's why there's a trial, right? Well, a hearing, but he's still incarcerated. He seeks first and foremost to clear his name. Equally important to him, however, is his family and the devastating effect that any violation of pretrial release conditions would have on his 3 young children. But you didn't think of your children when you were having sex with a young child? Interesting. Interesting. But put plainly, he has absolutely everything to lose should he fail to appear or violate any term of pretrial release, and everything to gain by seeing this case through to trial. Right? Yeah. Shake my head. I know. I know. We're all like, whatever. Oh, brother. Now he worries about the family. I know. He had a baby. His son was born the day after he allegedly unalived Sandra. Can you imagine? Can you imagine that whatever higher power you believe in gives you a life, a son, and you're over there abusing a young girl, and then you unalive her and her unborn baby? Like, it's wild. Although the government alleges that a certainty of a lengthy or severe potential sentence upon conviction provides incentive to flee, it does not by itself create a serious risk of flight. Yeah, no, it does. It does. Because I'm not going to lie. If I knew I was in prison, I'm just saying, hypothetically, allegedly, if I knew I was going to be in prison for the rest of my life, I might try to book it to a country where I can't be found. I'm just saying. He is trained to live through crazy conditions. Exactly, Cree. I didn't even think of that. The military and cop stuff make him more of a risk and more dangerous. You're so right. He's trained KILLER and a trained survivor. Exactly. Sadly, a lot of men cheat when their significant other is pregnant or postpartum. That's so effed up. It's like the time when you shouldn't be doing shit like that. Ugh, I can't. I'm like a total like supporter of women and children. So I'm like disgusted with men that do that. Like, I might have to end the live and go throw up. This fool was not cheating. He's a perverted predator. Exactly. Dude, she was what, 13 when she started the Explorers program. Ew. Yeah, no wonder his wife don't want nothing to do with him. Because it said at the beginning, if he gets out on bail, he'd go live with his mommy. Yeah, because his wife is done with his ass. She should be, though, 100%. Many cases, I know they have children together, but like, ugh, I'm disgusted for her and sad. Many cases which note that the possible imposition of the death penalty, for example, provides an incentive to flee, also present with other indicators of a propensity to flee, such as a transient lifestyle, a lack of employment, or the fact that the defendant's family had moved out of this jurisdiction. Mr. Farwell presents with no such indicators. Even for the defendants facing capital punishment, pretrial release is warranted where they have substantial family and employment ties to the community. Additionally, the elimination of the death penalty as a potential penalty, as is the case here, mitigates a defendant's risk of flight and is a factor in the release calculus. The First Circuit generally upholds detention orders based on serious risk of flight where defendants have insubstantial local community ties and or extensive ties to other jurisdictions. Detention orders have also been upheld where defendants have substantial means and or resources to flee. And it refers to United States Rudolph. Affirming detention order on a serious risk of flight grounds for a defendant charged with foreign unaliving where he would have accumulated vast wealth, owned property in Mexico, traveled frequently, and had extensive overseas contacts with and was intimately familiar with living long periods outside the country. Like Cree said, he knows people, he can survive. Yep. a woman's most vulnerable state. Exactly. Exactly. As sustained herein, Mr. Farwell has demonstrably long-standing and deep ties to his local communities in Massachusetts. This is where he has built and rebuilt his life and where his family remains. Raised without substantial means, Mr. Farwell has worked his entire life, but he is by no means wealthy. He has no ties whatsoever to any other jurisdiction aside from his brother, who relocated out of state and with whom he has no contact. The twin brother that was also having sex with Sandra Birchmore. Moreover, as part of their investigation, the government obtained Mr. Farwell's international travel records, which reflect planned family vacations. Aside from that, his only out-of-jurisdiction travel has been on behalf of the United States when he was deployed at various military bases and or fighting on behalf of our country. One need look no further, however, than Mr. Farwell's own conduct between Miss Sandra Birchmore's death in February of 2021 and his arrest in late August of 2024. Yeah, dude, you were already out long enough. Like, yeah, I know it took them time to build the case or whatever, but you were out for like 3 years, dude. To see that he poses no risk of flight, let alone a serious risk. For more than 3.5 years, he endured intense scrutiny from his former employer and colleagues, which resulted in the loss of his career in law enforcement. Okay, wait. You asked for it, dude. Like, I don't want to hear this bitching in these court documents is like not helping, I don't think. His personal life was dissected and misrepresented by the press and social media. Oh, brother, here we go. Here we go. Sounds like he had more than the young lady he murdered. Why do they even try? I believe it. I believe it. I don't know if it was another young female or other young females or older ones. He's a pig. Okay. Let me take a drink of my energy drink. Why? Call the wambulance. Yeah, suck it up in jail. If he had been a weed dealer instead of a cop, he would be convicted already, right? Exactly. They're like, oh, he fought for our country. Even more so than you should have been having sex with a young girl. Do not insult the pigs. That's funny. Had he any propensity or desire to flee, he would. Oh, I have this girl on TikTok that I follow, and she has like a pet pig. He like lives inside the house and stuff. I would have never imagined that, and I'm not like a fan of the pigs, but in both ways. But it's really cute to watch. So yeah, you're right. Don't insult the pigs. Okay, moving on. Had he any propensity or desire to flee, he would have done so when he became aware of the allegations, when the media first publicly reported on them, or when he was publicly named as a suspect in relation to any offense involving Sandra. My cousins have those. Yuck. Really? Yet in the face of daily unrelenting judgment, oh my, the crying, I can't. Mr. Farwell remained in his community with his family. He started his own business, registered it with the Mass Secretary of the Commonwealth, and took out a significant multi-year business loan, all which demonstrates not just his ties to Massachusetts, but his intent to remain here. He needed to start his own business because no one wants to hire a felon PDF file, especially one that was a cop. Potbelly pigs are pets. Oh, okay, that's what they have, I think. They can also be mean. Oh, aware of the allegations, aka got caught. I know. It's hilarious how they do this, huh? Unlike the government's speculative claims of risk of flight. Wait, did I already read this? A risk of flight, his own conduct is direct evidence that he poses no risk of non-appearance or non-compliance with pretrial release conditions. To the extent The government argues that the weight of the evidence, more fully discussed below, contributes to a risk of flight. Here, to presume the risk of flight from strong evidence of guilt would be tantamount to a presumption of guilt. This would impermissibly infringe upon Mr. Farwell's constitutional presumption of innocence and protection set forth. Finally, where the answer to whether a defendant poses a serious risk of flight is derived from a fact-specific examination to determine if there exist conditions or a combination of conditions that would reasonably assure defendant's appearance at future court proceedings if released. So he is working undercover as someone who is not a flight risk so he can run the first chance he gets. Exactly. Oh no, Angel Eyes, stay safe. The tornadoes. Yeah, you're right, Q. I lost my spot. Finally, where the answer, as outlined herein, conditions exist to both manage and substantially reduce any concerns regarding risk of flight. Mr. Farwell does not pose a serious risk of obstruction. As with flight, the BRA places the burden of the government to prove a preponderance of the evidence that a defendant poses a serious risk, obstruction, and that no condition or combination of conditions would reasonably assure the protection of the community from such obstruction. Evidence or allegations of some risk or a risk of obstruction is again not enough. Here, the government fails to establish a serious risk that Mr. Farwell, if released, would obstruct justice. Furthermore, a safety concern for potential witnesses is clearly insufficient. A court must identify an articulable threat posed by the defendant to an individual or the community. First, the government suggests that the charge itself is, by definition, rooted in obstruction, and detention is justified on that basis alone. If this were true, then there would be a presumption of risk of obstruction for all defendants charged with or convicted of obstruction or obstruction-type offenses. There is not. Instead, the only presumption that applies in this case is a presumption of innocence. Oh boy. In asserting that Mr. Farwell allegedly asked his adult affair partner to delete mutual messages that might prove an affair and conducted 2 Google searches on the scope of consent and celebrate technology, the government ignores. Wait, asked his adult affair partner? So not his wife? Wait. Okay, so his wife is his wife. He was having an affair because this is after Sandra was already unalived. Is that right? Oh my gosh. So he was having an affair with somebody else and he was graping. Well, it wasn't grape, I guess. Dating. Is that true? Is that what another woman of age? Yes, ATS. So not only a young girl, Sandra, but another adult he was having an affair with. Whoa. In asserting that Mr. Farwell allegedly asked his adult affair partner to delete mutual messages that might prove an affair. Oh my gosh, how disappointing for his wife. Wow. That's sad. Conducted 2 Google searches on the scope of consent and celebrate technology. The government ignores the equally consistent innocent reasons that would explain this conduct. Innocent reasons? Excuse me? It also ignores the fact that Mr. Farwell did not revoke consent or delete content on his phone after being contacted by investigators. Well done, Matthew. We're glad you didn't pull a pig Stephen Stearns and try to reset your phone. Good for you. Although the government emphasizes Mr. Farwell's law enforcement history and military experience with explosives, there was YouTube does not like that word. There was no indication whatsoever that any physical evidence was tampered with or destroyed prior to or after Miss Birchmore's death. However, in arguing that Mr. Farwell lied to the police troopers by minimizing the extent and nature of his relationship with Sandra, the government also ignores the fact that he never denied the affair and admitted seeing her breaking up with her at her apartment on February 1st. First of all, it wasn't an affair because Sandra wasn't old enough to consent when the 𝗍𝗍𝗋 and the affair started. Second of all, you break up with her the day you unalive her. Oh, how ironic. How ironic. I'm like, I'm ready to fight. Hey, Shawty, good to see you. Grooming is brainwashing. It does not lessen the act because they confuse and brainwash the victim. Exactly, Q. Yo. Ugh. Tell work that I am more important. Thank you, Asim. Good to see you. Even assuming arguendo that the government's allegations regarding obstruction are important, however, the inquiry for a serious risk of obstruction is not whether a defendant has previously engaged in obstruction or an attempt to obstruct. This only propels the government halfway to its objective. The question is not simply whether the defendant's past actions can be considered obstruction, but whether there is serious risk of obstruction in the future. Well, I don't know. This does not, I don't put it past anyone to have hidden devices or anything like that. Maybe I do watch too much true crime, but he should have texted her to break up, did not have to schmurder. Yeah, because remember in the timeline, the last live, Sandra's friend said, that Sandra she wanted him to be involved, even if he didn't want to be with her. That's what she wanted. She wanted to have him on the birth certificate and for him to be a part of the kid's life. So yeah, you're right. He didn't have to schmurder her. This does not mean that a defendant's past behavior should not be a part of the serious risk of obstruction calculus, but the government needs to show that there is a serious risk that these potential harms exist going forward. It cannot do so here. To the extent that as yet unproven allegations regarding past obstruction can establish a serious risk of obstruction, then the court must also consider both Mr. Farwell's countless opportunities to influence witness testimony and or to obstruct justice during the years after Ms. Birchmore's death when he was the subject of a lengthy investigation, and the complete absence of evidence that he did anything of the sort. Specifically, not a single witness has indicated to the government that Mr. Farwell demanded, instructed, asked, or made any effort to influence their statements or prevent their cooperation with law enforcement in either the state investigations or the federal prosecution. Significantly, the protective order governing law enforcement reports in this case does not require that the witness names and statements should be shielded from Mr. Farwell, and there has similarly been no allegation whatsoever that he sought to influence or intimidate any witness after his arrest. Thank you, Q. Q says, I told my work, you are more important, but they did not care. Sigh. I'm gonna have to contact them. Just kidding. Finally, Mr. Farwell submits that any concerns regarding obstruction can be sufficiently mitigated by conditions of release and monitored by pretrial services. These include no contact orders with witnesses, as well as restriction on Mr. Farwell's movements as outlined above. In alleging danger as grounds for detention, the government has a heightened burden of proof and must show by clear and convincing evidence that no condition or combination of conditions will reasonably assure the safety of any other person in the community. This requires proof that a particular defendant poses an actual danger, not a theoretical one. Moreover, neither the fact that a defendant has been charged with a crime of violence nor that he may face a life sentence upon conviction establishing a presumption of danger. An individualized assessment in this case demonstrates that the government has not and cannot meet its burden to show that Mr. Farwell poses a danger to any other person or the community. Wow. Threaded through the government's motion is the claim that because of the federal government indicted Mr. Farwell, where state prosecuting authorities did not, that somehow itself creates a risk of flight, obstruction, or danger. That argument fails when one considers first the arbitrariness of the timely. I have to sneeze. Hold, please. Okay, thank you. I didn't want to sneeze in your ear. Where did I leave off? Where state prosecute. Okay. The argument fails when one considers the arbitrariness of timing of Mr. Farwell's indictment and arrest. A review of the evidence suggests that the government formally began its investigation sometime in the fall of 2023, yet it did not charge Mr. Farwell by complaint or immediately arrest him, instead permitting him to remain in the community, in his home, and with his children and family. For more than 3.5 years following Sandra's death, Mr. Farwell's only interactions with police were in the context of traffic citations and motor vehicle accident response. He did not intimidate, influence, or harm any person, let alone any witness, and did nothing that would give the rise to the government's speculative claims of danger here. This course of events warrants a finding that he does not present a danger as he appears before the court today. Put simply, Mr. Farwell's conduct in the aftermath of Miss Birchmore's death and his arrest in this case establishes that he is not a danger and can fully obey the law. Possession of GUNS alone does not constitute clear and convincing evidence of danger. The government's argument regarding Mr. Farwell's access to and/or knowledge of the GUNS here is a red herring. His years of responsible firearm ownership, consistent with the strict laws of the Commonwealth of Massachusetts, prove his respect for the law and the safety of the community. Additionally, there is no evidence whatsoever that even when Mr. Farwell possessed these lawfully, he ever used or threatened to use them to harm anyone or commit any crime. What's more, after his arrest, Mr. Farwell's firearms have been relinquished. The government's arguments regarding Mr. Farwell's danger to children are similarly unavailing. Okay, see, yeah, this I disagree with. He is a danger to children. He is. In both the underlying Massachusetts State Police investigation and the FBI's investigation in the case, the government performed digital extractions on Mr. Farwell's phones and obtained records detailing his internet search histories and material and iCloud accounts. In none of that evidence did the government find one iota of child or anything that would suggest any prurient interest in children. The government's, just because he doesn't watch porn doesn't mean anything. The government's reliance, both involved presumptions of pretrial detention, which do not apply here. To the extent that the court has remaining concerns about danger should Mr. Farwell be released, conditions exist to mitigate those concerns, and any such doubts should be resolved in favor of release. If the court finds that Mr. Farwell is a serious risk of flight or obstruction or a danger to any person or the community, he is still entitled to release because there are release conditions available that will reasonably assure his appearance in compliance with judicial procedures. Nature and circumstance of the offenses charged. Mr. Farwell is charged with a serious offense in this case. Neither the fact that he has been indicted nor the fact that his charged offenses are serious, however, mandate detention under the BRA, nor is it a dispositive or determinative of whether there are sufficient release conditions that will reasonably ensure Mr. Farwell's appearance at trial and compliance with judicial procedures. The First Circuit has counseled that the seriousness of criminal allegations does not itself inform whether the circumstance of the offense justify pretrial detention. The government's argument appeared to suggest that any defendant charged with murder, manslaughter, or causing the death of another person should be denied on the basis of indictment and the government's allegations alone. The BRA, however, explicitly permits release even for defendants charged with unalivings from whom, unlike Mr. Farwell, the government is seeking the death penalty. Numerous courts have released defendants facing similar and or even more serious exposure than Mr. Farwell faces here. Even in Massachusetts state courts, where defendants are more commonly charged with unaliving and where those charged with the first degree unaliving have no right to bail, judges have issued a pretrial release orders for defendants. Should the court find that Mr. Farwell's charges weigh in favor of detention, however, that does not end the inquiry, nor does it require detention. As mentioned, courts must give due attention to all four factors and the nature and circumstances of the offense. 2, the weight of evidence. The government's emphasis on the weight of evidence permeates nearly every aspect of its motion for detention. Although it is an enumerated factor, courts have held that it is the least important detention factor. In cases where much of the case will likely hinge on the credibility of the government's witnesses, an assessment the court is unable to make at this juncture, then this factor is at best for the government neutral. Mr. Farwell submits that this case falls squarely in this category, but even if the court finds a factor weighs in favor of detention, conditions of release nonetheless exist to satisfy any remaining concerns regarding serious risk of flight, obstruction, and danger. Yeah, he really wants to get out. I don't buy it. I don't buy it. Although this is not the forum to determine Mr. Farwell's guilt or innocence, the government's claim about the weight of the evidence must be understood and analyzed through the lens of exculpatory and mitigating evidence that it both had in its possession at the time of the filing, its bail motion, and did not cite or acknowledge therein. This includes, for example, Ms. Birchmore's lengthy mental health history, including ideation and attempts dating back years before her death. Sandra's Google search history on the morning of February 1st, 2021, that reveals a focus on self-ideation, to wit, what color is the S-word ribbon. The schmexual proclivities the government attributed solely to Mr. Farwell that were in fact consensual features of Ms. Birchmore's relationship with multiple other intimate partners, including the actual father of her child. Oh, wow. So they're stating that he's not the dad, including the actual father of the child. Critically, what? Really? Interesting. Critically, the expert opinion of a board-certified pathologist with the federal government that corroborated the OCM's finding that Ms. Birchmore committed self-deletion, an opinion which the government obtained mere days before rejecting it and then retaining William Smock, who would ultimately support the government's theory of cause of death in this case. The government's claim about the weight of the evidence must be analyzed against the exculpatory evidence obtained after Mr. Farwell's indictment and arrest in this case. This includes forensic DNA testing, which revealed complex DNA mixtures from multiple contributors on nearly all tested evidence items, with all but one interpreted as having been between 4 and at least 4 contributors. Most notably, however, is the fact that Mr. Farwell was totally excluded from the DNA recovered from underneath Ms. Birchmore's fingernails, which corroborates observations of first responders who noted no signs of struggle in Ms. Birchmore's apartment. So just wait, because this is the defense, but we're going to still read their response, and that's where we get new information. So pay close attention. Moreover, Mr. Farwell's repeated denials of paternity, both to Ms. Birchmore and law enforcement, were proven true as DNA analysis confirmed that he was not the father of Sandra's fetus. So he's not the father. Allegedly. Though SA Special Agent Castroda's affidavit briefly mentions OCM's official determination cause of death, specifically that Ms. Birchmore committed self-delation by hanging, it is a fact which must be emphasized in the weight of the evidence analysis. When two board-certified government forensic pathologists opine that Sandra died by her own hand, where the only question put before a jury is whether Mr. Farwell committed a unaliving, it cannot be said that the weight of the evidence solely favors the government. Even where the weight of the evidence or the likelihood of conviction is strong, however, the court must find a relationship between this factor and a defendant's likelihood of making himself unavailable for trial. Where there is no such connection here, the factor should weigh in favor of release or at the very least be deemed neutral. The criteria set forth all support Mr. Farwell's release on pretrial conditions. These include his family and lifetime community ties, length history of employment, including extraordinary military service, limited but stable financial resources, and his lack of a criminal record. His lack of substance and or alcohol issues, paired with the fact that he has never been on probation, parole, release, or pending sentence for any offense, also weigh in his favor. Undersigned counsel needs not further belabor to the years of Mr. Farwell's respect for court proceedings and the related investigations that preceded in his arrest in this case. It is clear that he would conduct himself in the same manner if released pending trial. Even after his arrest, while detained in a federal pretrial facility, Mr. Farwell has conducted himself peaceably and respectfully. He has incurred no disciplinary reports and has maintained strong family ties. Importantly, his family knows of and firmly appreciates the seriousness of the government's allegation in this case. Mr. Farwell's request that he be released to a third-party custodian and that he live with his mother, not his wife and children, further demonstrates the seriousness which he takes this case. He has no desire to expose his children to further scrutiny or harassment while he seeks to clear his name. No, don't use that as an excuse. Your wife doesn't want to be with you. Is it his brother or one of the other law enforcement officers that were also involved? Yeah, that's a good question. For all the reasons, this factor clearly militates in favor of Mr. Farwell's release. The BRA mandates that Mr. Farwell be released pre-trial. The government cannot demonstrate that he is currently a risk of flight or obstruction, let alone a risk that could be considered serious or that he poses a danger. Should the court find, however, that such risks exist, Mr. Farwell is still entitled to release because there are conditions available that would reasonably ensure his presence at trial in compliance with court rules. Respectfully submitted, Matthew Farwell by his attorneys. March 26, 2026. Ooh, okay. Next document. I'm dying to see what they said in response here with the new evidence. Holy moly. I had not read that. Wow, okay. This is wild. This is wild. Trying to minimize his action, he still knew about the abusers and did nothing as law enforcement. What am I missing? No, you're right. You're right, Q. I absolutely agree with you. Okay, this is April 6, 2026. This is going to be good. This is them responding, basically. I think. Defendant Matthew Farwell is charged with premeditated murder of Sandra to prevent her from disclosing information about Farwell's other federal crimes. As alleged in the superseding indictment and described in detail in the affidavit supporting the government's motion for detention, Farwell, R-A-P-E-D, Birchmore as a child, continued to have sex with her when she became an adult, believed she was pregnant with his child, and unalived her on February 1st, 2021, staging the crime scene to make it look like she unalived herself. This crime and the supporting evidence described in the government's filings require that the court continue to detain Farwell pending trial in October. Yes. The facts described in the government's motion for detention and the affidavit of the FBI special agent remain true. Moreover, in the 19 months since Farwell's arrest, the evidence proving Farwell's guilt has only grown stronger. Nevertheless, Farwell moves the court to release him into the community just months before he stands trial for the premeditated unaliving of a young woman and her unborn child facing a potential life sentence. The factors the court must consider under 18 USC support detention now even more strongly than they did at the time of his arrest. Thank you. I was over here like screaming. There's clear and convincing evidence that Farwell is a danger to the community and the preponderance of the evidence that is a risk of obstruction and flight. Farwell should remain in custody pending trial. Following Farwell's arrest on August 24th, 2024, the government moved to detain him pending trial on the grounds that he's a danger to community and poses a serious risk of flight and obstruction. At his arraignment, Farwell agreed to voluntary detention. On October 28th, 2025, the grand jury returned the superseding indictment, adding an additional charge for unaliving Sandra Birchmore's son in the violation 18, whatever. The case is set for trial to begin on October 5th, 2026. Here's their argument. The evidence supporting detention is even stronger now. Thank you. The evidence proving that Farwell committed the offenses alleged in the superseding indictment has gotten stronger since the defendant's arrest. Now, there's DNA evidence tying Farwell to the unaliving of Sandra and her unborn child. There is additional corroboration indicating that Farwell committed statutory when he abused 15-year-old Sandra Birchmore. Oh, I'm sorry, she was 15, not 13. There's no difference to me, but okay. There's more evidence indicating, I shall correct myself. There's more evidence indicating that Farwell unalived Birchmore to avoid accountability for other federal crimes. And there's additional evidence regarding Farwell's state of mind in the weeks and days before Sandra's unaliving, all of which indicates that Farwell planned the unaliving well in advance. Farwell's DNA was on the ligature around Sandra's neck. New DNA evidence, I haven't read this. I know this has been out for like a week. New DNA evidence conclusively ties Farwell both to the crime scene and the weapon. By way of background, in May of 2021, the Mass State Police Crime Laboratory conducted tests and found DNA on multiple items that state investigators recovered from Sandra's apartment. Sandra's underwear tested positive for the presence of sperm cells. Fingernail clippings tested positive for the presence of DNA. The ligature that was around Sandra's neck tested positive for the presence of DNA, specifically male DNA. However, despite detecting DNA on these items, no meaningful conclusions could be drawn from this evidence in 2021. That is because state investigators did not obtain DNA from Farwell or anyone else. That changed in August of 2024. As part of the FBI investigation, they obtained a federal search warrant authorizing agents to obtain a DNA sample from Farwell. Farwell's DNA was compared to the DNA found on the ligature from which Sandra hung, as well as the DNA under Sandra's fingernails and sperm in her underwear. While Farwell correctly states his memorandum that his DNA was not found under Sandra's nails, he fails to mention that Farwell's DNA was found on the ligature that tied Sandra's neck to a closet door handle. The presence of Farwell's DNA on the weapon, the strap used to asphyxiate Sandra, is of course highly inculpatory. Furthermore, Farwell's sperm cells were found in multiple locations on underwear that Sandra was wearing when she was found dead on February 4th, 2021. The presence of Farwell's sperm in Birchmore's underwear renders it highly likely that he lied to the police detectives during his brief interaction with them in the school parking lot on February 6, 2021, when he claimed that the last time he had SCX with Birchmore was in October of 2020. This lie is relevant to Farwell's state of mind and his consciousness of guilt. Farwell's federal warrant compelled DNA sample also provided insight into the paternity of her unborn son, whom Farwell is also charged with unaliving. DNA evidence excluded Farwell as the father of Birchmore's unborn son. However, in light of the evidence that Farwell had unprotected SCX with 23-year-old Sandra Birchmore repeatedly and intentionally for months on days she was ovulating, it is not surprising that there is not a single electronic communication between Birchmore and Farwell between December 28th, 2020 and February 1st, 2021, in which Sandra suggests that anyone other than Farwell is a father of her unborn child. Also, during that period, there are no text messages between the two in which Farwell denies or doubts paternity. Rather, the evidence indicates that Farwell believed he was the father of Sandra's unborn son. It is a fact that Farwell held this belief and not the fact that he was mistaken that will be most relevant at trial. There is more evidence of Farwell's statutory, of Sandra. Since Farwell's arrest, the government has obtained additional evidence that Farwell committed the statutory, of Sandra when she was 15 years old. As described in the FBI's special agent affidavit in support of detention, on multiple occasions, Farwell acknowledged taking her virginity. In electronic communications obtained by investigators, Sandra said this happened on April 10th, 2013. On that day, she was only 15 years old. Sandra had also shared with others that Farwell took her virginity when she was 15. In addition to this evidence, the government has obtained medical records and other evidence indicating that Sandra asked a doctor for birth control on May 1st, 2013, just a few weeks after Farwell began, exploiting her sexually. There is also evidence that on May 30th, 2013, Sandra told a doctor that she was having intercourse, providing cooperation for electronic communications, indicating that Farwell exploited Sandra when she was a child. There is additional evidence of Farwell's motive. Yo, this is wild. End of story. Yes, 𝗍𝗲. There is more evidence that Farwell unalived Sandra because she was a victim of his federal crimes, which included deprivation of rights under color of law, coercion, and enticement of a minor, and wire fraud. The government has continued to amass evidence of the unique criminal nature of Farwell's relationship with Sandra. As a threshold matter, Farwell's memorandum refers to Sandra as his adult affair partner. Oh, okay, so he was referring to Sandra as his adult affair partner. So he didn't have another lover. It was just Sandra. He suggests that he deleted communications with Birchmore and or encouraged her to delete communications with him because he was merely having a consensual extramarital affair. It's not consensual when she's a child. She can't consent to that. And then there's grooming and everything else that comes with that. So I call bullshit. However, since Farwell's arrest, FBI agents have found evidence that Farwell engaged in multiple extramarital affairs. Oh, there you go. He did have lovers, and the FBI has the evidence that Farwell engaged in multiple extramarital affairs with various adult women during the 8 years. He was simultaneously grooming, exploiting, and continuing to have sex with Sandra. The evidence indicates that Farwell's conduct was much more brazen in these non-criminal extramarital affairs. Multiple witnesses disclosed to the FBI that Farwell had told them about at least one of his extramarital affairs. By contrast, Farwell endeavored to maintain the secrecy of his long-term sexual relationship with Birchmore. He repeatedly instructed Sandra to delete text messages from him. In addition, when Farwell found out that Sandra had disclosed their relationship to a friend, he texted Sandra with apparent anger, quote unquote, "You also told me that no one knew about us. And you have no idea how bad what she did is." That's when the friend called his work. Remember the last slide, we went over that. The employee of the Stoughton Police Department who took the call reporting Farwell's relationship with Sandra stated that Farwell was enraged and ordered the employee not to speak about this to anyone and to never talk about it again. So that is threatening another civilian. Farwell's relationship, a witness, because that person's going to be a witness in the trial. Farwell's relationship with Birchmore was not like the sexual relationships he had with other adult women. Its genesis was a crime and he acted accordingly. There is also additional evidence that puts Farwell's motive in context. Since Farwell's arrest, FBI agents have honed in on evidence indicating that Sandra knew she was a child sex exploitation victim and she was willing to leverage it to get what she wanted from Farwell. In text messages with friends, Sandra referred to herself as a victim of Farwell's crimes. After learning she was pregnant, Sandra became even more assertive and resistant to Farwell's manipulation. Birchmore contacted attorneys to begin planning for potential issues related to paternity, child support, and support. Child custody and support. FBI agents have interviewed multiple witnesses and reviewed Sandra's communications that indicate Sandra had a plan to obtain Farwell's financial support for the child they both believed he fathered. And these communications indicate that Sandra was willing to use her role as a victim of Farwell's crime to ensure that she and her unborn child would be financially secure. There's additional evidence of Farwell's state of mind. The government's prior filings describe some of the compelling evidence showing Farwell's state of mind and consciousness of guilt. Among other things, Farwell told Sandra to delete their text messages, to stop putting things in writing. He agreed to accept a key to her apartment. He inspected her closets. He appeared at her apartment on short notice wearing a mask, and he lied to the police detectives. The evidence has continued to build on this front. Several of Farwell's former colleagues at the Stoughton Police Department have provided evidence that corroborates Farwell's mounting stress in January of 2021 and tends to prove the government's theory of premeditation. One witness indicated that when he was at work in the fall of 2020, Farwell started texting feverishly and taking private phone calls. When the witnesses asked Farwell what was wrong, Farwell decided that he had to put crazy back in the bag and then everything would be okay. The witness indicated that Farwell became increasingly stressed in January of 2021. On February 2nd of 2021, while Sandra lay dead and undiscovered in her apartment, Farwell uncharacteristically texted this witness to ask the witness if the witness was working and whether anything was going on at work because he was bored as hell sitting in the hospital. The witness recalls this being the first and only time Farwell expressed any interest in what was happening at the Stoughton Police Department when he was not on duty. Of course, however, the timing of this check-in makes sense. Sandra was dead and there had been no public reports of her death. Another one of Farwell's former coworkers told FBI agents about another ominous statement by Farwell in the lead up to Sandra's death. Approximately 2 weeks before Sandra's death, the coworker and Farwell were eating at a restaurant. The witness told Farwell that he looked stressed, and Farwell indicated he was having relationship problems with a woman other than his wife. Whoa. This is new information. They were like, we're going to save this one. This is a horrible crime. I hadn't heard this one. Thanks, Melly. You're the best. Oh, thank you, Psycho. Yeah, there's a playlist. I actually covered this case for the second live ever on my channel. This was my second live or my first. So it's wild. When the witness asked if they could help Farwell, Farwell said the problem was going to take care of itself. Whoa. The foregoing new evidence is important because it's inculpatory, but it also reveals that as the pressure mounted in January and February 2021, Farwell devised a plan to unalive Sandra. This track record should give the court pause, especially anticipating that a similar pressure will grow as trial in this case approaches. The evidence of Farwell's reaction to life-altering pressure demonstrates that the court cannot be assured that he will comply with conditions as that date approaches. A predator is always a predator. Yes, Evie, exactly. Predators don't get well. That's not a thing. The court should reject Farwell's arguments about risk, flight, and obstruction. Thank you. Thank you. In this motion, Farwell argues that he is not a risk of flight because he did not flee in the years between Sandra's death and his federal arrest. The court should reject this argument because it ignores the critical change in circumstances since his arrest. In the time between Sandra's death and August of 2024, Farwell believed that he was not the subject of any criminal investigation. He had a good basis for that belief. For much of that time, there was no criminal investigation into Sandra's death. To the extent that there was any short-lived criminal investigation, at no point was Farwell seriously considered as a suspect in a homicide. He did not know or suspect that he could face life in prison until the FBI arrested him in August of 2024. From that point forward, Farwell's incentive to flee changed drastically. That's because they said that she unalived herself, and the family was like, no. Well, what was remaining of her family. On February 6, 2021, employees of Sandra's apartment complex informed the state police that they had security video footage from February 1st, 2021, which showed a then unidentified masked man entering Sandra's apartment building after she was last seen alive earlier that day. Subsequently, members of the Canton Police Department, Canton, yes, you heard me right, Karen Reed, corruption, etc. Canton Police Department and state police identified Farwell as the masked man entering the building. Within hours of that identification, a state investigator contacted Farwell and invited him to meet with the state investigators at the parking lot of a local elementary school. There, they discussed Sandra's death for approximately 30 to 45 minutes. During that conversation, Farwell was not asked to provide a DNA sample or any evidence whatsoever from his personal phone. After the February 6, 2021 conversation with state investigators, Farwell retained possession of his personal cell phone for 3 days. After that 3-day period, state investigators asked Farwell for consent to search his phone. Farwell declined to permit state investigators to search his personal phone. On February 9th, 2021, he consented to a limited search of messages between him and Sandra. However, he indicated he had already deleted these messages, claiming he did so after he broke up with her on February 1st. Okay, whatever, Matthew, you ass. As a longtime law enforcement officer who had previously partnered with the state police in Norfolk County, Farwell knew that if any meaningful state investigation were ongoing, his DNA would have been compelled and his devices would have been seized. Here, Farwell knew that no search warrant had been conducted at his home to search for the clothing he was wearing the night of the crime. No location data related to his phone was sought to determine where he went before or after the death of Sandra. Instead, after giving state investigators his phone on February 9th, Farwell told at least one witness, quote unquote, they won't find anything because he had, quote unquote, wiped his phone. These are all going to be witnesses at trial. If Farwell had any concerns about being the subject of a criminal investigation, those concerns were allayed on February 11th, 2021, when Farwell's twin brother was interviewed by state investigators. In that interview, state investigators assured Farwell's brother that any investigation was not criminal in nature and that no one was in trouble. When Farwell's brother told Farwell that he had been interviewed, Farwell assured his brother that it would be over soon. In the fall of 2021, Farwell's brother learned that the Norfolk County District Attorney's Office had concluded its investigation. Indeed, Norfolk County District Attorney Office records indicate that the office's investigation was officially closed by at least August of 2021, if not earlier. Wait, did his brother tell them this? That's why they don't have a relationship now, allegedly. At no point prior to, but his brother was also having sex with Sandra Birchmore. They both were. So they're both disgusting and they both need to be in prison. At no point prior to August 2024 was Farwell treated as a subject of a murder investigation. He could be certain that to the extent any investigation ever did exist, it was closed by at least August of 2021. The current posture and corresponding incentives to flee could not be more different. A federal grand jury has charged him with multiple crimes carrying a possible life sentence. The FBI has conducted a thorough investigation. His DNA is on the ligature found around Sandra's neck. Witnesses have shared their recollections of his incriminating statements, and the court has set a trial date at which a jury will decide his fate. Under these circumstances, his decision to stay put prior to August 2024 is of little significance. Farwell's post-offense conduct includes his efforts to falsely portray Sandra as S-word and other criminal activities involving extremely risky behavior. For background, out of the dozens of witnesses FBI agents have interviewed, not a single witness has indicated that Farwell expressed any remorse regarding Sandra's death. Quite the opposite. At least one witness told agents that Farwell joked about Sandra's death. Witnesses also indicate that after Sandra's death, Farwell spread rumors about Sandra's mental health struggles, likely in an attempt to influence those who might be wondering whether he was responsible for her death. Ew. Yeah, he knew. He totally preyed on her. Ew, yeah, keep him under the drill, please. Farwell made other attempts to lead people to believe that Sandra died by self-deletion. Two witnesses separately disclosed that in the months after Sandra's death, while Farwell was on leave from the police department, Farwell purported to reenact Sandra's death. According to witness disclosures, at a small private gathering, an intoxicated Farwell was discussing Sandra's death. During that discussion, Farwell sat down under a doorknob and demonstrated the position in which Sandra was found, assuring the skeptical witnesses that it was possible for someone to commit suicide in that manner. Whoa. He's sick. At that time, it had not been publicly revealed that Sandra was found hanging from a doorknob. They have so much shit on him, it's not even funny. And then, yeah, yes, Debbie. OMG is right. Can you imagine he's drunk at a party? He shows his friends, oh, this is how she was found. Ha ha ha. And that wasn't even out yet. And all these people are clearly talking to the detectives and the police. It says that there's dozens of witnesses. In addition, even though the defendant did not flee before the FBI arrested him, there is evidence that Farwell engaged in other criminal conduct during the period between Sandra's death and his arrest. Specifically, there is evidence of a sexual incident involving a young adult woman that took place after Sandra's death. This young woman reported to local police that in the summer of 2021, she met Farwell at a bar. The woman reported that Farwell bought her an alcoholic drink. The next thing the woman remembers that night is waking up naked in her bed as Farwell was walking around her bedroom looking for his keys. He roofied her? The woman does not remember how she got home and indicated that her lack of memory was wholly inconsistent with the 2 or 3 alcoholic beverages she had consumed. She disclosed that her neighbor had also texted her twice that night because he was concerned that a truck was idling in her driveway and a phone inside the truck was audibly ringing over and over. After the incident, the woman was concerned about what, if anything, had happened, so she texted Farwell. Farwell responded by confirming they had sex and told her they should do it again. Holy balls. I don't think that none of this was out. All the exhibits are under seal too. Oh my goodness. Oh my goodness. FBI agents interviewed another person who was with Farwell on the night of the foregoing incident. The former friend of Farwell confirmed that he saw Farwell approach the woman in the bar. The woman appeared to be drunk and crying, and Farwell began to flirt with her. The former friend confirmed that Farwell and the woman left the bar at the same time. Other witnesses have confirmed that Farwell's wife had been calling his phone multiple times that night in an attempt to contact him, corroborating the neighbor's statement that he heard a phone ringing in the truck relentlessly. Another friend of Farwell's, whom he was out with on the evening in question, indicated that Farwell's wife contacted him in an attempt to locate Farwell. When his friend confronted Farwell about it, Farwell admitted that he had sex with the woman from the bar. Whoa. So he's out after Sandra was unalived. Wow. Doing all of this. Ew. Ew. Farwell's attempt to persuade witnesses of a false narrative regarding Sandra and the circumstances of her death, as well as the evidence of his alleged SCX conduct with an incapacitated woman following Birchmore's death, are circumstances alone that should give the court pause when deciding whether to release a defendant. But here, when coupled with the other overwhelming evidence described in the government's motion and Special Agent Castrato's affidavit, these facts make it clear that the court cannot be assured that the defendant will comply with any conditions of release. Farwell's arguments are without evidentiary support. Farwell's motion focuses on the OCM report indicating, based on the information available to the assigned medical examiner at the time, that the medical examiner believed that Sandra died by self-deletion. Importantly, the medical examiner did not visit the scene of Sandra's death and relied heavily on the first responders to thoroughly investigate the scene. As it turns out, this reliance was misplaced. At the time of Sandra's autopsy, the medical examiner received a report from the Canton Police Department containing just a single paragraph stating in a conclusory fashion that Sandra's death was self-deletion by hanging. In that one paragraph report, Canton Police also misidentified the item from which she hung. So they're like, no. The police made a mistake, and that enabled the ME, the medical examiner, to do its appropriate investigation. The officer calls it a scarf. It was a duffel bag strap. He hung her from a duffel bag strap. Wow. However, he strangled her, but you know what I mean. Moreover, within 1 hour of responding to the scene of Sandra's death, local law enforcement officers were notifying the medical examiner that there was no foul play at the time of the report. Similarly, state investigators submitted a report on February 4th, 2021 at 7:03 p.m., just a few hours after Sandra was found. In that report, the state investigators called the case Birchmore self-deletion Canton. They noted that the antidepressant medications were documented at the scene, but did not notify the medical examiner of several other critical facts. For example, when the medical examiner conducted an autopsy and made her initial findings, she did not know that Sandra was found with a necklace broken from its chain down the front of her body. This evidence, which is consistent with the struggle, was not given to the medical examiner. State investigators did not preserve the necklace for the medical examiner to inspect. Further, at the time of autopsy, no investigator had reviewed Birchmore's cell phone. Everyone involved with this police investigation we know is corrupt. They're all kind of the same. Canton Police Department, they should all be held accountable for this. Therefore, the state investigators could not tell the medical examiner that the phone contained evidence that Farwell was in Birchmore's apartment on February 1st, 2021. Without that evidence, state investigators could not tell the medical examiner that Farwell had just told Birchmore he was arriving at her apartment at that moment her phone locked for the final time. Similarly, they could not tell the medical examiner that Farwell was in Birchmore's apartment when her phone recorded its final step data. Finally, they could not tell her that her phone was never accessed again whatsoever after Matthew Farwell was seen on surveillance video leaving her apartment. Had the medical examiner known that someone was with Sandra when her phone activity stopped and the last time her movements were recorded, she could have considered these facts when making her determination in this case. Nor did the medical examiner have the benefit of the DNA test results that now show that Farwell, the person who was in Sandra's apartment when her phone stopped moving, also left his DNA on the ligature from which she hung. Because state investigators had not reviewed Sandra's electronic devices, the medical examiner did not know that Farwell had a history of choking Sandra during sexual encounters. She did not know that Farwell had engaged in a new pattern of DV in early of January 2021. She did not know that Farwell had recently searched the closet near where she was hung. Oh my gosh, this is so brutal. Moreover, it was not revealed to the medical examiner that 11 days before Sandra was found deceased under a doorknob, a witness had called the Stoughton Police Department and exposed Farwell's relationship with Sandra. No one told the medical examiner that Farwell reacted by warning the Stoughton Police Department employee never to tell anyone about the call and sending Sandra angry text messages about the serious nature of that disclosure. Finally, the medical examiner noted but did not understand the significance of the premortem injury to Sandra's clavicle. At that time she made her findings, the medical examiner did not notice the injury to Sandra's clavicle, which was caused while Sandra was alive, matched the buckle of the knot found behind Sandra's head, suggesting that she could not have died in the position in which she was found. He strangled her and then he staged it. The cases Farwell cites are distinguishable. In his motion, Farwell cites that the court murder cases in which defendants obtained cash bail. None of these cases he cites are analogous to his case, in part because only one of them involves a defendant who has been charged with first-degree unaliving, and that case was quite distinct from Farwell's. The federal cases that the defendant cites are even less persuasive, as they are highly distinguishable from their and therefore inapplicable to the present case. Lastly, the government observes that much of the defendant's memorandum is devoted to portraying Farwell as a family man and war hero. Oh my God, I love this. However, the defendant fails to address the additional evidence about Farwell's pertinent characteristics that show Farwell is a danger to the community and risk to others. Yes, for example, the government's memorandum in support of detention summarized Farwell's long track of using physical and sex violence, including deeply troubling evidence recovered from his phone. While honorable military service is always a laudable characteristic, Farwell's ties to the community and years of service failed to stop him from sexually exploiting Birchmore and unaliving her and her unborn child. I love this. That's literally what I said. It didn't stop him. Conclusion. While the defendant stands charged with 2 crimes committed on or around February 1st of 2021, the superseding indictment and evidence cited in the government's filings indicate that Farwell has been committing crimes for years. His crimes began while he was a police officer exploiting the 15-year-old Sandra Birchmore. He committed wire fraud many times over when he visited Sandra to engage in acts while on the clock working as a police officer. Then, as alleged in the superseding indictment, he brutally unalived Sandra, strangling her with a ligature in order to prevent information about his crimes from getting to law enforcement. This makes Farwell dangerous, and the preponderance of the evidence shows he is both a risk of further obstruction and a risk of flight. For the reasons stated herein, as well as in the government's initial memorandum in support of detention, the government asked the court order the defendant detained pending trial. The government further requests that if the court is inclined to release defendant on conditions, it stays its order for such time to permit the government to file a motion for revocation of the order of release. Respectfully submitted, the United States Attorney. I cannot believe it. I had been waiting to read that document. Wow. Wow, wow, wow. This is a crazy case. I most absolutely will be covering this trial in the fall. Unless they offer him some kind of deal or whatever, you know. I hope not. I really hope not. This is a crazy case. It absolutely is a crazy case. I do have a playlist, so there's not much on there. I know I did a live on it a while ago when I first started my channel, so it might not be the best, but the most recent live I did is a detailed timeline of the case. So definitely go and watch that to get more background on the case. And shout out to you guys and thank you for sticking through all almost 50 pages that I just read to you guys. So you're really narrative this good. Thank you. Thank you for that, Hands. So trial coming up. I'll have to check if there's more hearings before then, but I don't know. I'm so glad I found this channel. I'm going to go through your playlist. Oh, almost like everything. So have fun. I appreciate the support. Anyways, justice for Sandra Birchmore. Thank you guys for hanging out. Please, please, please tap the like button on the way out. I will be back for more true crime after this. This next live should be Kenzie. Thank you, Master Mally. Yes, Psycho. With that being said, you reminded me of Gypsy. We will continue JLR, Laura Owens, and Gypsy Rose tomorrow. Those are on the calendar for tomorrow. So we'll see. I will be dropping a Kenzie video tonight, pre-recorded. Well, you know what I mean. And then I will be clipping more of the JLR book reading, and I still need to finish that JLR book. So we shall do that tomorrow. I really want to do Kenzie tonight, finish 2020. So we'll see. Wow, I'll rewatch what I've missed. Yes, please do. Shout out to you guys for being here. Please tap the like button on the way out, and I shall see you guys on the next live. And again, justice for Sandra Birchmore. Later. Thank you for being here.